Welcome to this webinar, or better, the first part of 2 webinars on data protection. My name is Peter Vermeulen. I'm the Chief Legal Officer of Foyer, and I'm also a member of the board of the ALJB. Data are everywhere and are also safeguarded and treated everywhere. And therefore, it is important to be protected, that our data are protected against the prying eyes of Big Brother. Now, in the European Charter of Fundamental Rights, there is an Article 8 who specifically treats about data protection. And even in that article, it is said that an independent authority must supervise the treatment or the processing of those data. And therefore, we are very grateful today to have a member of that independent authority in Luxembourg, the CNPD. On the other hand, we have to say that in Europe, our data are relatively well protected, but this is maybe less the case in other parts of the world, and maybe also in the US. And therefore, the US is important because in the US we have the GAFAMs, the Google, Amazon, and also Microsoft. And maybe we can say, well, these GAFAMs, these US GAFAMs, these are the bad guys of data protection. But in business, we need these American companies to digitalize our business. And digitalizing our business is really a question of survival. So therefore, we are also happy to have today someone, a representative of Microsoft, who is digitally here from Brussels, and who will also be speaking to us. So on the one side, we have the protection of data, and on the other side, we have the business side, Microsoft, who is helping our business to digitalize. And in between, we have also someone with whom I professionally have some connection. We have the data protection officer, because as in-house counsel or as data protection officer, we have the questions from our IT department who wants to outsource data to the clouds. On the other side, we also have the obligation to respect the legislation, so we need to find a solution between the two, and that is what this webinar today is about, to find a solution to keep going with our business, but whilst also respecting the data privacy laws. Before introducing our moderator, just some practical points for this seminar. So as indicated, this seminar is the first part of 2. The second part will be more on the sanctions regime, and we will have the same moderator. We will also have someone from the CNPD, and then the sanction regime of the CNPD is a hot topic because the CNPD is sanctioning enterprises, so Amazon more than 700 million, and also some insurance companies have been fined by the CNPD. So on the 25th of November, we will go more deeper into those CNPD sanction regime. For today, our seminar will take, we will have a presentation of about 45 minutes, so a 1:15 or 1:20, the presentation will be finished, and then there will be time to ask questions. So in order to ask questions, you can simply use, at the bottom of your screen, there is a possibility over YouTube to ask your questions. You can also start asking your questions now, so you don't need to wait until the Q&A session at 1:20. You can also send your questions right now. Then also the participants who have registered for this first part of the seminar will automatically receive also the link for the second part of the seminar, so the second part on the sanctions regime. And finally, both the slides and at least some part of the recordings of the seminar of today will be accessible to the members of the ALJB on the ALJB website in the section reserved for members. So finally, Vincent, you will introduce the speakers, but I have the pleasure of introducing you. So you are a partner here at Nauta de Til. Thanks, Nauta, for hosting this event. You are leading the IP, ICT, and competition departments here in Luxembourg. But I think your experience in particular in outsourcing and IT outsourcing will be really valuable today for this seminar. So thank you, Vincent. The floor is yours.
Thank you, Peter, also for inviting us and that we can co-host this webinar under. It's done in a very professional manner. So as you have indicated, so ladies first, we have around the table virtually Sigrid Windmolders, who is Principal Corporate Counsel at Microsoft Belgium and Luxembourg. So probably if you have some dealings with Microsoft and there will be some negotiations, there is a risk that, that you have Sigrid also on the table. We have also Mr. Abran of the CNPD, who is, if I'm not mistaken, Chief of the Service de Guidance, so yes, the guidance service, and who for already a long time I know also through the emails as being Mr. International Data Transfers, if I may say so. And then on my right-hand side, I have Eric Bedel. Thank you, Eric, for being there as well. So, Chief Privacy Officer at Franklin Templeton. And it's really a unique setting that we have, because we have, as Peter has said, we have one of the major cloud service providers around the table. We have the authority, and also Franklin Templeton. It's a very big US investment firm who has transatlantic business, so who deals every day with the problems around international personal data transfers. So I will also briefly introduce the topic of international data transfers. I think we are all legal persons on the webinar, and most probably most of you have heard about the Schrems II judgment from 2020, so last year. And but I would like to briefly introduce actually the topic again, so it's a refresher, so that we can go on with a few questions that go a bit more in detail. So, is it possible to have the slides? Yeah, thank you very much. So, international personal data transfers before that famous Schrems II judgment in 2020. So a very classic approach. So normally you have to assess whether there are international data transfers in your operations. Then you have to identify the countries to which the data are transferred. And there you have to see whether that country benefits from what we call an adequacy decision. So that's a decision of the European Commission, whereby the European Commission has assessed the legislation in that country and has come to the conclusion, yes, that country provides actually for an adequate level of data protection. For example, Japan benefits from such adequacy decision, Uruguay, Israel, now in the Brexit context also the United Kingdom. And there was a very specific adequacy decision, and that was the Privacy Shield. So the Privacy Shield is not a national adequacy decision, but is a self-certification scheme whereby US organizations can self-certify that they're compliant with the GDPR, and if that procedure has been complied with, then the European Commission came to the conclusion, yes, the transfer of these data can be done towards these organizations. Unfortunately, the financial institutions were excluded from the Privacy Shield anyway, but if you use, for example, cloud service providers, it was very useful because the recipient of, for example, Microsoft Corp benefited also from this adequacy decision under Privacy Shield. then you have a kind of cascade mechanism. So if there is no adequacy decision, you can organize your adequacy a bit yourself by adopting what we call standard contract clauses. Again, the European Commission has drafted some standard contract clauses. I don't know how to explain it otherwise, but they're the standard contract clauses. And if you adopt these, so you put them in place between EU data controller, for example, and your cloud service provider who receives maybe data in the US, then your data transfer was also deemed to be compliant. And then you also have binding corporate rules. I think Eric will say a word about those. That's more binding rules within a group of companies whereby you try also to organize yourself that adequacy which is lacking in the third country. And last but not least, if you cannot rely on these your own organized adequacy mechanisms, you can always rely, well, not always, but in certain circumstances, on what we call derogations. So, for example, if the person has provided his consent, or if the data subject, the organization has concluded a contract in the interest of the data subject, and the data transfer is really necessary to execute that contract. Yeah? So that is also important. Now, you have the, in July 2020, the Schrems II judgment of the Court of Justice. To be very short, invalidation of the Privacy Shield, because the European Court of Justice came to the conclusion that this level of data protection in the US was maybe not up to the European standards, because there are some mass surveillance programs in place. The recourse for individual data subjects was also not as it should be, and this led the European Court of Justice to the conclusion we have to invalidate the Privacy Shield. The principal question in that judgment was rather whether the standard contract clauses, whether you still can use them, because of course, if there is no adequate level of data protection in a third country because of a mass surveillance program, how can standard contract clauses then actually be an adequate mechanism to fight against these mass surveillance intrusion? And there the Court of Justice has said, indeed, the standard contract clauses, they can remain valid, but where you also have to look whether in practice they can be enforced, because there are some clauses in these standard contract clauses. For example, you have to notify the data controller where there is a request for access to personal data, and very often an order of US authorities prohibits an organization, for example, a cloud service provider, to give that information, then that standard contract clause is not enforceable. And there the Court of Justice said, there you have to see, you have to assess actually the local laws and their impact, and whether these standard contract clauses can still be enforced in practice. And if not, you have to take supplementary measures. And if you cannot take these supplementary measures, of course, you cannot rely on the standard contract clauses, and you fall back on these Article 49 derogations. We also have seen in practice that, I don't know whether that is also your feeling, that the derogations have gained a bit in importance again. So there is still some appetite to rely on them after the Schrems II judgment. So very quickly, the EDPB, who is the European organization with all representatives of all national data protection authorities, has luckily, or also unluckily in some cases, issued some guidelines on which supplementary measures you have to put in place. So first of all, I think it's very good that they have indicated kind of life cycle of how you should go about international data transfers, first to identify them. Because post-Schrems II, what we also have seen is that a lot of clients have woken up and said, which international data transfers do I have? Normally they should already know it, but and then to assess actually on which mechanism the international data transfer is based. And if needed, if you cannot rely on an adequacy decision, and if you rely on standard contract clauses, to see what supplementary measures I have to put in place. And there the EDPB guidelines have issued some clarity with a focus on technical measures. So from the moment that you can put in place effective pseudonymization of the personal data and or effective encryption, and also with separate key management, because if the key management is within the AWS environment, for example, yeah, then Amazon can still have access to the data, to the keys, so then it may not be as effective as it should. So the EDPB comes to the conclusion, for example, if you use cloud services, yes, you can use them, but then you have to have a proper state-of-the-art encryption mechanism in place and or pseudonymization. For example, if you deal with health data, it's also better to pseudonymize them on top. The EDPB has also proposed some contractual measures and some organizational measures. I think they're nice to have because really the focus is still on the technical measures, because these contractual measures and organizational measures will also not stop actually US authorities from having access to your data, whereas a good encryption mechanism or a good pseudonymization may have that effect. So, but so then you have to make that assessment and then see whether in some cases you have to rely on these famous derogations. So here, again, we a small practical step plan where we show a bit the line of reasoning, adequacy decision, yes, no. What is also important, a very practical point, is there are new standard contract clauses for the international data transfers, and if you use them, and you have to use them after 27 September of 2021, and if you use this set of standard contract clauses, and it's a standard contract clause you put in place with a data processor, typically an IT service provider, then you do not have to conclude a separate data processing agreement. As you know, with a processor, you have to conclude a data processing agreement. Well, if it takes place in the context of international data transfers, the SECs will also function as a data processing agreement. So a few recommendations. So identify and map your international transfer. Know your transfer. It's not know your client, but know your transfer. Propose SECs to non-EU EEA partners. You also have to see with your business partners who receive personal data in a third country, what do they offer also in terms of supplementary measures, and you also have to re-evaluate regularly these measures. And don't forget to remind your data subjects also about the fact that an international data transfer is taking place. And even when you can rely on an adequacy decision, you still have to inform the data subject that there is an international transfer taking place. That's also one of the takeaways, minor takeaways, of the famous WhatsApp case in Ireland. So we come to the question part. Sigrid, we ended a bit with the topic of the supplementary measures, and that some IT service providers have maybe have to come up a bit help also a bit their clients to implement the supplementary measures, and I think that's especially the case with a cloud service provider. Many cloud service provider have a US mother company, and on the basis of jurisdictional rules, of course, US authorities can find a way to request to produce data. I think Microsoft has taken some initiatives in this respect. We heard about some of them, but maybe you can give a small wrap-up what Microsoft has done in that field until now.
Yeah. Yes, okay. Thanks, Vincent, for asking. Indeed, after the Schrems 2 ruling and also then with first the draft recommendations of the EDPB and then the final recommendations and also the new standard contractual clauses, we did, as we do constantly, in fact, we did some investments and we also introduced some changes. Now, if we, and Vincent, you already highlighted it, that you have a different type of measures. You have organizational measures, there can be technical measures, also contractual measures. If we look into the technical measures, which are indeed very important, then a lot of eyes are on encryption. And maybe for the audience, just a very brief explanation. When you encrypt data, you can do that at different time moments. So you can encrypt your data while it is in use. You can encrypt your data while the data is in transit, and you can also encrypt the data when it's stored, so when the data is at rest. And of course, as a company, it is important to understand what is the information or what is the data that I have and what is the data that I want to be encrypted, and then which encryption solution do I need for my data. If we just bluntly take that we have, let's say, 3 types of confidential information. One can be business information, such as your trademarks, your business plans. Another one can be maybe if you're in a highly regulated environment, such as healthcare, or, for example, just take them as examples, the financial sector industry, if you, for example, are a bank. So if you have highly regulated information, that can be another category of data. And then you can also, if you look at the nations, you can have information related to your national defense system. So you can have really, truly top secret nation-related information. So you have to look within the company or within your entity and to see, okay, what is the business that I'm in? What is the data that I have? So encryption plays an important role in securing your data. And also within the GDPR, encryption is seen as a protective measure. And it is also pointed out as being a technical or an organizational matter, even in some cases. If you have at Microsoft, we offer very strong encryption to our customers. And we also try as much as possible to be transparent about our practices, and we defend also the customer data. So one of the measures that we've taken, and that is a contractual measure, was built on, in fact, already a habit or a way of working that we had in the past, but now we went one step further and really made it as a contractual commitment. So what we do is that we stand up for our customers' rights. So next to the strong encryption that we offer to our customer, we also say if we receive a request from a law enforcement agency, no matter from which country that it is coming from, we look into that law enforcement request. We validate whether it is a legally valid request, yes or no. And in first instance, we will push back because, and I'm talking here about the enterprise world, so both private and public sector customers, the data is your data. This is not the data that Microsoft owns, so it's your data. So it makes sense that law enforcement agencies reach out to you directly instead of to Microsoft. Sometimes this is, if for example, you are a company that is acting in the criminal field, because this is what these investigations are about terrorists, about terrorist attacks, about a criminal behavior. So then sometimes it can be that the authorities, that the agencies will not reach out to you directly because you're the subject of the investigation. And if we cannot notify you as a customer because we are legally prohibited, then we will not do so either. But the first steps are always we will redirect it to you as a customer and we will notify you as a customer. But we've taken it one step further, and we do say as well, we will defend our position, and we will defend your data in court, and we will go up if needed to the highest courts. If we believe that there is a conflict, so if we have a legal basis to do so and there is a conflict with law, between the laws of the different countries, then we will push back and we will fight against this request. Now, in any case, if at the end, if we have to obey the law, because of course, as any other company, it is the intention to obey to legislation. If we have to hand out data to a law enforcement agency in a criminal investigation, it will always be the very specific data. So we will never open any backdoor for a law enforcement agency. We will never hand out any encryption keys, or we will never provide the government with whatever way to break encryption. So this is not something that Microsoft does. On top of that, so next to challenging government requests on enterprise customer data, we also provide, and there's also a contractual commitment that we've taken recently, we will also provide a monetary compensation to your customers' users, so to data subjects, if we had to disclose their data in relation to a legally valid request of a law enforcement agency. And if in fact there is a conflict, if this should be in conflict or would be in conflict with the GDPR, then we will provide a monetary compensation to the data subject, to the customer's users, in order to compensate for the damage, material or immaterial damage that person suffered. Now, if we go back to the encryption and the technical measures, as I already mentioned, so you can protect data not only at rest and while it is in transfer, but you can also protect it while the data is in use. Now, maybe as a reminder, it is worldwide saying that encryption is not a measure to circumvent legislation. Encryption is a measure, a technical measure, in fact, to protect and to secure data against an unauthorized access by a third party. There is a possibility to encrypt your data also while it is in use, so while the data is processed. And you can, I don't have a technical background, so I cannot explain you with the technical details, but you can compare it as the data being in a kind of enclave, a secure enclave. So it is, the data in use is protected by performing, in fact, a computation in a hardware-based, trusted execution environment. So you can compare it to this secure enclave. What is good to realize, and it's also, again, as a customer, the reflection that you have to make and weigh in all the risks that you as a company are willing to take. You have to weigh in that if in such a scenario where you make use of, and we call this confidential computing, when you make use of confidential computing, there is also, again, a shift from the risks, more risks are shifting back to you as a customer, because in these types of solutions where in fact there is neither the cloud provider nor a third party who can access the data in use, it means automatically that there comes again more risk from the security aspects on your shoulders as a customer. A last element that I would like to highlight is Microsoft is doing a lot of efforts and investing a lot of time and money in a project that we call the EU boundary. And what do we strive with this project? Our plan is to, by the end of next calendar year, to make sure that there is as less as possible data transfer from the EU to the US. And the way that we're going to do that is not only keep the data at rest in Europe, in the European boundaries, but also the data while processing it. So consequently, there will be way less data, and including then potentially personal data, that needs a transfer outside of the EU boundaries. So we keep on investing in changes, both from a contractual perspective, an organizational perspective, and a technical perspective, to keep up also and to remain compliant with the evolving regulatory landscape.
Thank you, Sigrid. That's a very nice wrap-up of the initiatives. I think in a lot of cases, when we're talking about encryption, one of the weak points was always identified as, encryption in transit and at rest. That's good, but what about encryption in use? And I'm quite happy that you put the finger on the wound, that Microsoft also has a solution on with respect to the encryption of data in use. Now, turning to the regulator, so the latest version of the EDPB guidelines, contrary to the first version, the last version also had one small addition that is quite important in practice, and which leaves some kind of risk assessment to the data controllers, because the first version was a bit strict, and the second version indicates that you can also have a look what is the concrete impact of the data, international data transfer on my processing, and see what the impact of the third-party legislation is on that. Of course, it's a very high burden also on organizations to look what is this third-party legislation talking about, what practices, because that's another addition of the EDPB guidelines, that you not only have to look at the legislation in the third country, but also what are the practices. Well, sometimes you don't know what the Indian Secret Service is doing. So it's a very difficult exercise. How you look at that as a regulator, because of course you have in some cases, very blatant violations of the rules on international data transfers. But from the moment that there is a burden on the organizations to have a look in what is the the third country legislation, and what are the practices, you're gliding in a kind of slippery slope path, whereby organizations are quite unsure how far they have to go in the assessment. And what is the stance of the regulator on that?
Yes, well, first of all, thank you for mentioning those recommendations from the European Data Protection Board. I took them with me, the recommendation 1/2020 on supplementary measures, and then there are the recommendation 2/2020 on the European Essential Guarantees. And indeed, the recommendation 1/2020 gives, I hope at least, data exporters, so European data controllers, for example, who would like to transfer data to a third country, so outside of the European Union, some practical steps. So there are actually 6 steps. The first is, like you mentioned, know your transfer, but then there is a third step, which is actually, like you said also, the necessity to assess whether the law or the practice of the country of the third country of destination is maybe preventing the data importer to actually respect the safeguard, for example, to respect the standard contractual clauses that it signed. So this is an important, of course, an important step in practice, and it's not easy. So I can recognize that it's not very easy. But I hope the recommendations address a little bit this issue and give some practical insights. So, for example, I think, well, yes, one thing also to keep in mind is that it only applies this assessment of the third country if there is no adequacy decision that was granted by the European Commission. So, for example, the European Commission recently granted Japan with an adequacy decision. So, for example, if you, as a data exporter, as a European data as a European, European data controller, for example, transferring data to Japan, you don't need to assess whether the Japanese legislation prevents transfers, because this was already work done by the European Commission. That being said, still a lot of countries do not have an adequacy decision, so that's still an important work, and especially the United States, as you mentioned, do not have any adequacy decision. They had some kind of hybrid system with the privacy shield, but it's now being invalidated. So I think it's like a good advice would be first to ask maybe the data importer in itself. So either the data importer is part of a group of companies. So for example, it's your sister company that is in the US or in China or in another third country. So it's sometimes interesting to ask first the data importer, because he has more knowledge about the law and also about the practice of the third country in question. So that's the first point. And then also you as a data exporter, you can check first whether there is any data protection legislation in the third country in question, whether there is any data protection authority that is independent, whether this data protection authority, if it exists, issued some guidance or recommendations. Also, something that could be interesting would be to check if the third country in question signed any multinational agreement, for example, whether it signed and ratified the Convention 108 plus of the Council of Europe about data protection, because this Convention 108 plus applies to some European states, not only European Union member states, but also extra-European Union states, but also it is open to extra-European countries, so it might be interesting, although it is not maybe the only thing to look at, but it's maybe interesting. Also, what could be interesting would be to look at the jurisprudence of both the European Court of Justice, the European Court of Human Rights, but also of national legislations maybe. And finally, maybe the data importer can provide, and some do provide statistics or reports about, like for example, how many times did a government agency ask them to reveal some personal data, what are the let's say the protection in place in that country. So that's all kind of things the data exporters could look at. And finally, I would say that if after this analysis, data exporters are still not very sure whether the third country in question prevents or does not prevent to apply the safeguards, then a good advice would be to put in place some additional measures in any case, because it's never too much to put some additional encryption or pseudonymization or organizational or contractual measures in place, even if not needed. It's better to do it this way than the other way around, actually.
Yeah, that's also a very valid point. If you're talking about encryption, pseudonymization, some people forget that it's actually also, generally speaking, a security measure that you should put in place in accordance to article, or where it's appropriate, of course, that you should think about it, to put it in place as a general security measure. And also, it's interesting that the data importer has to help, of course, the data controller or the European-based data exporter to have an insight in the legislation. And it's also in this sense that the new standard contract clauses have been drafted in a way that that is also an obligation that is incumbent on the data importer in a third country. So Eric, of course, Franklin Templeton doesn't need an introduction, US firm, so probably a lot of transatlantic data flows. So for you, it's not just a question of, it's a technical data flow in the context of a cloud computing service. For you, it's very tangible. It's also data, what we call then in the clear, very often. How do you go about it? Because the EDPB guidelines have also provided some use cases. And from the non-regulator side, there is also a kind of feeling there was some use case also in just in the context of a multinational firm, and that it's very difficult actually to exchange data in a way that probably before Schrems 2 was a bit permitted. But how do you go about it?
So first of all, what is important to mention is that we decided at the tail of the GDPR project to globalize the data privacy program, which means that we are applying the same program everywhere around the globe, based on the GDPR principles, which is helping a lot. Just a concrete example, we have decided to use the record of processing activity globally.
Okay, that's
that's
a
a
good
good
baseline.
way, exactly, just to understand all the processes that are using data, and then you can start to identify the transfers based on those processes. Because if you don't know what you do between US and India, you will not know the transfer between those two countries if it's outside of Europe and you just decided to do the ROPA, the record of processing activity, for Europe only.
Sure.
So that's one of the first things that I would really recommend. What we have also decided to do is just risk rate the processing activities themselves to understand which one is more risky for the employees, for the customers, and list them by this risk criteria. And then we did the same for the data transfers when we have identified them. Just understand, let's say, if we transfer to China or, let's say, Russia. Russia, you know, with homosexuality is having some legal issues. So you don't want to transfer this kind of information for your diversity plan to Russia. So this would be considered as being a risky transfer. So then you can compare both risks, the processing activity and the transfer risk, and just identify if you should do it or not. So that's another way to think about it. Another thing that is quite important to mention is, as a global group, we want to make sure that we are treating fairly employees. It doesn't make sense to have employees that are less well treated in India, in Africa, in I don't know, Japan. We talked about Japan before, compared to the European employees. Of course, the unions that we have internally would be really pissed about that. You know, like, hey, why are you protecting so much European people and you don't for US people? You know, so I think what is important for us is just to make sure that we can export or extend the program as global as possible. Of course, there are some limitations that you can always thought about, like, for example, the budget. Of course, it's always difficult if you extend the rights request to all employees that's not the same as just European employees. So that's one of the limitations. But we are moving to automation to overcome those issues, which would make sense for us to offer the same thing for all customers, all employees around the globe, having the same services, which is leading to the next point, which is about the contractual obligation. So what we decided to do for covering those transfers, international transfers between the different entities of the group, because we are an American group, but we have entities in 37 jurisdictions, so that's a lot. Several entities. We have partners, very close partners, close distributors that are also part of the group, and we are acquiring a lot of new companies regularly. So we decided for us to use an internal agreement, contractual agreement, based on the SCCs. So when we are acquiring a new company, where we are connecting a new company to the group, they need to sign those SCCs for those transfers, because that's two different companies, of course. But we have also linked that to the SCCs, so it's easier for us to manage it in a way. And last but not least, when we know those things, we know what are the obligations, and we are able to push some practices that will be used for VCRs, and I'll come back to that later on. Data minimization, for instance. you don't need to have all your human resources data all around the globe. It's locally managed. You don't need to know if that person is having, I don't know, an access to the coffee machine for facilities. You don't need to know that from the US if it's a European employees, you know. So all those stuff, you don't need to share it. And this data minimization principle is built at the heart of the program itself. So it's something that we will use together with the SCCs or the internal group agreement that I was mentioning before. We will mix that and build some BCRs. First of all, they will not be, well, in the first step, it will not be asked for being authorized or approved by the regulators. It will take a bit of time for us to prepare for that. But at least we will use that internally as a guiding principles and just have a real code of conduct that is helping people to understand what they can and what they can't do. And that's really what we are pushing about. Maybe another thing that I could give as an advice is make sure that you understand all the new projects or the new usage of data, and you are sizing that with all the program I was mentioning before it happens. And I think that's really important, the privacy by design. Again, that's a GDPR principle, but we are applying that globally. So all around the globe, if someone is having a new project, collecting information, personal information, using or modifying an existing database to add, I don't know, a birth date, for example, they need to go with what we call the privacy engagement form. So they need to contact us with a list of questions, and we can assess it. And then we can say, okay, for that, it means you need to change your notice. You need to do this. You need to assess the transfer. Or if the transfer is not authorized, you need to find another way to do it. Pseudonymization, encryption, and so on and so on. So that's really what we do. And just to give maybe a concrete example before I hand over, but I think what is important, one of the most difficult things that we are trying to do now is the huge push for many countries, UK, US, on the diversity data. They want to know how diverse your workforce is, yeah. Which is a really good sentiment, you know, that's coming from a very good angle. That's really a goodwill just to help employees and make sure that we are not discriminating people. But on the other hand, it can be used for something else. So that's why we need to be really clear about that. So we did the full study. It took more than a year for this study because the data, of course, needs to be collected globally and shared globally because we get some RFPs, we get some questions from all the countries. But at the same time, it's very risky, as I said before. So at the end of this study, we just said, okay, well, the risk assessment is maybe showing too big of a risk. So instead of doing it that way, why don't we use a third party with an anonymity? The third party don't know the name of the employees. They will just have a site where people are having an ID and just collect that with this ID, you know? And then it's not connected to a country, it's not connected to a people, it's not connected to a firm. And then you have your figures. You can say 55% of my employees are male or 45 female. So it's one way to encrypt it in a way that nobody can say, hey, as a company, you have used that for firing that person. You know, we don't know. It's not us. You know. So again, you need to have a lot of contractual agreements with this company and make sure that there is no reversibility on the pseudonymization or anonymization. That's another topic. We are, by the way, another advice if I can give, we are testing that as well because we have some very strange surprises. Like you say, hey, it's totally pseudonymized or anonymized, but you are able to reverse because there is just 2-3 people in that country. So of course, there is just one man. Of course, you know who it is, you know. So you need to test it as well. It's not taking account like that, you know. Test it too.
Yeah, that's very insightful. I think pseudonymization on a country level like Luxembourg is indeed sometimes raising some questions. Also a very important point. I think the underline is be compliant with your provisions on international data transfers, but it's also not everything. It's just one component of the GDPR, and mind your proportionality principle. I think that is one of also a very important takeaway. So just quickly back to Sigrid. So we also have sometimes a feeling that two things are being mixed up, in my opinion. For example, the Schrems II judgment was based on the so-called mass surveillance measures of the US authorities. And then now in that discussion, we also have discussions like, yeah, but independently from these mass surveillance measures, you also have the Cloud Act. So on the basis of which US cloud providers can be forced to hand over data, but what some people forget to say, it's a handover of data in a very specific criminal procedure. So, because in the post-Schrems 2 discussion, all things are mixed up, like in Schrems 2, Cloud Act, and I think the Court of Justice didn't even talk about the Cloud Act, and I think there are other non-compliance issues with the Cloud Act. But what is your stance on that, Sigrid? Because if I understood correctly your previous explanation, if you hand over data of a data subject, you also give some kind of remuneration to the compensation to the data subject, because most probably in that specific context, maybe, I think, or maybe surely, Microsoft switches from its role of data processor in a data controller modus. So what is the stance of Microsoft on that?
Yeah. Well, first of all, with the Cloud Act, I think as many companies, we are still very much looking forward to the international agreements to be closed between the either the European Union and the US. We know that United Kingdom already did conclude its agreement with the US authorities, because one of the goals of the Cloud Act was also to make it less burdensome for the states in order to exchange data in relation to a criminal investigation, because we all know that every country has its mechanism to exchange data and to gather data in this frame in relation to criminal investigations. So that was one element of the Cloud Act. Another element was also the Cloud Act did provide to specifically then cloud providers more the possibility, or the firm possibility, to also stand up and to challenge law enforcement requests. What we've done also through a contractual commitment laid down or stated in our general terms and conditions. If we look at the Cloud Act, it is always a difficult one, because we know that, of course, the business is not only done with the US. We have other countries outside the EU as well. And what we do towards our customers to help the customers and to provide them with visibility on the practicalities of the countries, the laws applicable to law enforcement, is we track reports. So you can find at Microsoft Trust Center, you can find per country, you can find the reports related to law enforcement requests. And that shows that give you a lot of insight on, and of course this is per country. You can track it also at a global level, but it is not only linked to enterprise customers, to the opposite. It is mainly the bulk of the requests that we receive is related to the consumer world, to the consumer business, and not at all to the enterprise customers. So that helps you as a company and as a customer also to, again, evaluate your risk. How realistic is it that you as a company will be subject of such an investigation? Next to the law enforcement requests from all the different countries, so including from the US, we've also challenged some years ago the US government, where we in fact provided, due to this challenge, we received the possibility to also make public the requests related to national security of the US. So that is also something that you can find at the Trust Center. And then related to any how to call it, any surveillance or mass surveillance in order of I don't know if you're familiar with the Executive Order 12.333, which provides the US government with the possibilities to do some surveillance, Microsoft does not cooperate with that surveillance. So this is surveillance which is done completely on a complete unilateral basis. As any, we see that at Microsoft also, that nations, they have mechanisms to do a kind of surveillance, espionage, and then it comes back to how secure is your environment? What measures have you in place from a technical perspective to protect your data and to make sure that this cannot be done, so that there cannot no hacking or disclosure of information that cannot take place.
No, that makes sense, and it brings me also to maybe another unclarity in the whole framework, and that's the following. If you, for example, conclude a cloud agreement with Microsoft, and the support and maintenance comes from outside the EU, then you have a fairly high probability, or it could be that there is an access to content data, even when there are also some other mechanisms to control that with customer logbox mechanisms, etc. But if we're looking at a constellation where the data is in the EU, and imagine that the EU boundaries project would be put in place, but there is a request under the Cloud Act, but as long as there is no specific request under the Cloud Act, the mere possibility that there once may be a transfer of data or an access request, we at Nauta Util, we have taken from a legal point of view, in that particular context, and as long as there is no specific requests from a law enforcement authority, that there is no transfer. So I would like to know from a regulator point of view, because it's thin ice, because a lot of people say, because of the mere possibility that the Cloud Act could be triggered, you have to you have to comply with everything. We think that it's a thing that certainly must be taken into account in the risk assessment, and where you can ask yourself, is there a transfer at all until that moment materializes?
Yeah, well, that's a very good question, because the notion of transfer, although it is a core notion of the GDPR, because the whole Chapter 5 is about international data transfers, it's never defined in the GDPR. So you can check in all articles of the GDPR, there is no definition of data transfer. So it's a more difficult question than it looks like. The CNPD now, together with its European counterparts, is in the context of the European Data Protection Board, working on draft guidelines on the interplay between Article 3, so the territorial scope of the GDPR, and Chapter 5, so the chapter about international data transfers. And in those guidelines, the EDPB will give more insights about what actually constitutes data transfer, yes. But basically what I can already say now is that you have to have three different elements to qualify as a transfer. First, you have to have a data exporter, or either a data controller or data processor, who is subject to the GDPR. Second, this data exporter needs either to actively transfer or to make data accessible to a data importer. And that's the third element. You have to have a data importer, which is also another, a separate entity, so another data controller or data processor, which is in a third country, so outside of the European Union. On that basis, I think you actually need to have a transfer, so a communication or an access or an actual access of personal data to qualify as transfer. So I think this might give you
which narrows down the discussion to
yes.
making available.
Making available
So-
what is it. But yeah, I know that the Cloud Act is a bit of a tricky legislation because it may apply extraterritorially, so also in the European Union, but also some data exporters might never be even subject to
Exactly.
the Cloud Act. So it's also something to take into consideration. If you never actually give away or make accessible some data to the US enforcement authorities, then there is no transfer in that
Exactly.
case. That's an important thing
Yeah.
to mention, and you already mentioned it. So.
Well, it's a position because
Yes.
sometimes we see that too often transfer is the potential of having a transfer, and we believe that there is no support in the GDPR. It doesn't say a possible transfer, but it's a transfer. So, so thank you very much for this insight, and also what we already have a scoop on what is going to come. Very brief concluding remark, because we go a bit on overtime. Maybe in 1 minute, Eric, because I'm really curious about it, but you replied already a bit to that question, like, because you have a global role, and how do you go about? You have already said that the GDPR is a kind of baseline. And what do you see, what is the impact of the other data protection legislations, and how do you combine that?
Yeah, so we have built, again, a form. We are using a tool with form, so we are doing that a lot, to analyze and assess new laws, new privacy laws or data protection laws around the globe, and just match them with what we have. And see, okay, we have that, we don't. Okay, this new law says this and that. I think maybe just to say from a global side of it, to your question, there are some good news and bad news. There are some good news that says in the US, we are seeing a huge interest now in privacy. People are getting interested into their personal data, which was not the case before, led by California. Of course, we are a company headquartered in California, so we are really interested by that. But there are a lot of debates on the federal legislation and different states' legislation, so that's a really good thing. I believe there will be an adequacy decision in some time. I don't know when, but it's going to happen. I'm pretty sure about it. The less good side of it is, like, we have seen a lot of new countries, including what they call the data localization requirements, like India, like China, that says you cannot extract data, or if data is entered into the country, even worse, you Russia, need to keep a copy in it. You know, so that's more concerning and less easy to deal with. But I would say that generally speaking, globally speaking, we are seeing a good trend that people are following GDPR, at least embracing the principle of GDPR if it's not exactly the same text. So for us, it's going to be easier in the future. That's maybe my outtake of it.
It's a good thing to hear that you have a kind of knowledge center about about the foreign legislations, which we all need. So
I do have 2 people in my team just doing that full time. So
wow, that's impressive. So so thank you very much. I think also on a concluding note, we also have to watch out. Of course, that was a bit under highlighted, whether there will be a privacy shield 2.0. We see in the market also that there is some good discussions from the US that is going towards that. But on the other hand, when we're talking about when is a legislation providing an adequate level of protection, we also have to look at what we are doing in Europe as well. And there we don't have to be hypocritical about it, that there is also a surveillance, and that we also have a case law from the European Court for Human Rights, who, in my opinion, also has lowered a bit the threshold for mass surveillance, which could maybe make that if the US shifts a bit to the privacy side, and maybe the European Court of Human Rights lowers a bit, that there could be maybe some common ground of compromise. But of course, I'm not in these high-level discussions, but it's a personal opinion. But I think there could be some potential in that and this as a concluding note. So thank you very much for being here. Thank you for my guests. Thank you for the co-host. And I hope you enjoyed it. And if you have any questions, you can address them to Peter or to myself. The slides will also be made available later on. Thank you.
Thank you.
And thank you, Sigrid, of course, for virtually being here You're of course amongst the guests even, but it shows that that digital transformation of the daily life functions. Thank you very much.
You're welcome. Bye.
Thank you.
Thank you.